The other thing I'd like to talk about is
Sure.
that there's a definition of residential properties. So even the name of the act is a little bit misleading in terms of what it applies to. And what I mean by that is this. It definitely applies to any house or a building with no more than 3 dwelling units. So anything 1 unit, 2 unit, 3 units is prohibited.
Yeah.
But presumably, if it's more than that, it may not be prohibited if there's more dwelling units than 3. But then there's another definition that talks about any land that does not contain a habitable dwelling, so it doesn't have a home on it that can be occupied, and is zoned residential or mixed use. So presumably, I mean, certainly that catches vacant land or a lot that has an old home on it that to be torn down, that would be caught. But it probably will also catch commercially zoned, because of the mixed use zoning, commercially zoned land. Is also probably caught by this this prohibition.
And that's right. And residential land as well. That's
correct.
And that's really and that's where the commercial practitioners are really screaming like bloody murder, because there's a lot of foreign companies that do buy residential land and stuff,
or
like
commercially zoned land, mixed use
plazas and things like that. So it's very interesting, that whole piece, right?
Correct.
Well, good news all around.
We
got 2 years, so the countdown begins.
It'll be 2 years. I mean, obviously that could be extended, but right now it's 2 years. There are some acquisitions that are not caught by the prohibition. So if someone is acquiring a residential property from a death, so through a will or divorce or separation or as a gift, that's not caught. The rental of a residential dwelling is not prohibited. Transfers under a trust, only if the trust was created prior to January 1, would not be prohibited. And transfers resulting from the enforcement of security. So where a foreign buyer or foreign national holds a mortgage on a property and ends up having to power of sale or enforce that property, their security, and ends up with the property, that is not prohibited. The consequences for contravening the act is a fine of $10,000, which can be imposed on the buyer as well as any person that assisted that buyer. So obviously that would catch, real estate agents, brokers, and lawyers, and so on. If the act is contravened, so the contravention has occurred and it's caught later, that does not invalidate the transaction. So in other words, it doesn't make the transaction illegal per se, but the government can apply to the court to get an order to force a sale of that property, to get it out of the foreign buyer's hands. And once that property is resold, the foreign buyer can only receive the same amount of money that they paid for the unit, and any excess money is defaulted to the Canadian government.
Wow.
So that's part of the penalties.
Okay. Yeah, and I think there's a lot of great questions. Any more we can kind of talk about that, and we're going to be circulating this as well. But I'm thinking in my head, so if a foreign buyer lent money to a Canadian and then they defaulted, quote unquote, then the foreign buyer that gave the money in a mortgage, they'll be able to go power sale and keep the property?
Potentially, that's something. But if that's part of a scheme, in other words, if it started out as that, and that was the plan all along, I think everybody in the piece would have a problem.
Okay, got it. Look, there's been some urban myth and ways of getting around. That's why I just want to expose some of that, just so people can be aware of what's going on.